Hello everyone. I welcome you all to the third part or the third session of this course, which is on drafting a memorial. Memorial is also called as a written submission. In my last two lectures and videos, I hope you all have got some understanding of what exactly a moot court competition is, or what exactly mooting is, and how we research for a moot court problem, moot court competition and a moot problem for that matter. So now we will be discussing how we draft a memorial, because this is the most important part of the moot court competition. So moot court competition typically is structured in the sense that we have to first prepare our written submission, which is the part that I'll be discussing, draft our memorial. We have to submit that. And after that, if our memorial is selected, in case there is a memorial selection round in a moot court competition, if our memorial is selected, then we proceed for the oral rounds. However, in some moot court competitions, there is no memorial selection round. So in that situation, what happens is that you submit your memorial whenever the date is decided by the organizers. You prepare for your oral arguments and you go for your oral rounds. So these are typically the two ways in which a memorial selection, in which a moot court competition functions. So let me discuss with you today what exactly is a memorial. Now, a memorial is nothing. It's just a written submission which contains all the arguments which have been raised or which have been taken by a particular party, right? As you're aware, a moot court competition has two parties, A and B. A is the person who files the case, which also happens in a courtroom scenario. A is the person who files the case. B is the person who has to defend the case. So there are two parties in a moot court competition as well. Now your written submissions or your memorial basically forms the basis for your oral arguments. As I explained, it has the arguments or the arguments which a party wants to take. That has been mentioned in a memorial. This memorial has to be drafted by both sides. Now, when I say both sides, in a moot court competition, a single team has to represent both sides. One side would be for example, would be the petitioner. The other side would be the respondent or the plaintiff or the defendant, as the case may be, it depends. So a single team has to prepare memorial for both sides, for the side of the petitioner and for the side of the respondent as well. The most important aspect which a lot of people tend to miss out on is that when you are focusing on drafting a memorial, I do agree and I do understand that law is important and your research is important. However, the most important aspect to this is the competition rules, because your competition rules will provide you exactly the sort of guidelines which you have to keep in mind for drafting your memorial. Now, when I say guidelines, I mean the competition rules more often than not gives you the word limit, gives you the spacing details, gives you the alignment details, and this is very important when you're drafting your memorial. As you all may be aware of, and for those who are not aware of this, memorials are always marked upon by the moot court organizers. So your memorials form 50% of the marks which you get in any moot court competition. Hence, it is very important for us to present the best memorial possible. And when I say best, I mean best in terms of the structure, in terms of the content, and in terms of the look of it. Hence, always focus on the competition rules before you start to draft your memorial. Now, let me take you and discuss the components of a memorial. What are the components of a memorial? Now, the first important aspect or the first important component is a cover page. Imagine the memorial to be a book. Let's just go and let's just discuss this as a book. So similar to a book, a memorial also has a cover page. It will have a table of contents, index of authorities. Of course, a book may not have an index of authorities, but I'm just trying to give you an analogy so that you understand. List of abbreviations. This is new. Statement of jurisdiction. Let's say this is more like a foreword which a book has. Okay. Statement of facts or the synopsis of facts. Statement of issues, summary of arguments, arguments advanced, and prayer. I have just listed the elements here, and I will now be discussing each and every element with you in detail in today's video. Let me take you to the first element, which is the cover page. Now, a cover page is basically the front page of a memorial. All right. The cover page of each memorial must have the following information. First is the name of the forum before which the proceedings are being conducted. Let's say the case is before the Honorable Supreme Court of India, or let's just say it's before the Honorable High Court at Delhi. Depends. That will depend on the moot problem. Which forum are you to appeal, or which forum is your case pending at? The title of the competition, the name of the case. The name of the case will be, let's just say, if I have two parties, X and Y, X versus Y, right? X and others versus Y. Similar to that. The title of the memorial, which is the memorial submitted on behalf of the plaintiff or the petitioner or the applicant, or memorial submitted on behalf of the defendant or the respondent, as the case may be. All right. So these are 4 things which your cover page ought to have, apart from certain other things which I will tell you. Now, mostly what happens is that in a moot court competition, only for the purpose of ease of identification, the cover pages for the plaintiff or the petitioner or the appellant is usually blue. And for the person who's defending the case, the cover page is usually in red. This happens mostly. It is not a set practice. It depends from organizer to organizer. The most important part which you should keep in mind while preparing your cover page is the team code. Now, this team code is usually given by the organizers at the time of your registration. So when you register for the moot court competition, normally the organizers will give you a team code. Now, this team code is given so that there is no the identity of the team which is participating or the name of the college or the name of the participants is not revealed. So going forward in the moot court competition, the team code will be your point of reference for anything. Okay. So your team code should also be visible on the cover page on the upper right side of the cover page. That should be the point where your team code should be specified. Always remember that on the cover page, never mention the name of your college, name of your university, or your name or your team's name. Never mention that, because that is a ground for disqualification. Let me show you an example or a sample of a cover page. I hope it's visible. This is how a typical cover page looks like. So if you see, we have the team code at the top right corner. Then we have the name of the forum. So let me now take you and show you a sample cover page. Now, a sample cover page typically looks like this, which is this cover page which is on your screen right now. If you look at this, this is the cover page for memorial on behalf of the appellant. This is blue in color. If you see, the top right corner has the team code. Then we have the name of the forum, which is before the Honorable Supreme Court of India. This was in SLP under Article 136 of the Constitution. So we can always write that, especially if petition under Article 136 of the Constitution. Or if you are suppose approaching the Honorable Supreme Court under 142, you may mention that also. It depends. This is the name of the parties in the matter between State of Delhi versus Jai Shah and others. This is simply how you have to put it. All right. So this is how a typical cover page looks like. This can also be, of course, read if it is if it is being made from the side of the person who is filing, who's defending the case. Okay. So then in that situation, it would be read. However, in that situation also, the name of the parties or in the matter between, the name of the cause title, which is State of Delhi versus Jai Shah and others, will remain as is. Just don't think that if you're making the memorial from the side of the respondent, so it would be the other way around. No, you will still put the same way that it is written in this cover page. Okay, let me take you to the next component, which was the table of contents. Now, why am I focusing so much on these small components of memorial? Is because, as I explained, memorials have marks. All of these components add up and give you marks for your memorial. Hence, it is very important for a team to keep in mind that this is going to add up to your ultimate score, which will decide whether you qualify and whether you win or not. Okay. So table of contents. Now table of contents provides the structure of the memorial. It understand this to be a simple table of contents which enlists all the information that you have mentioned in your memorial. If you would notice, going forward, arguments advanced or the main arguments will form the largest part of your memorial because the most amount of focus is on that. So subheadings can also be mentioned under this table of contents for ease of reference. So the next important element is table of contents. Now, table of contents basically provides an index to the memorial. It's basically important for us to have table of contents written properly so that somebody who's reading the memorial, including the judges and your opponents, is able to easily navigate through the contents of the memorial. All right. So you should ideally put corresponding page numbers as against the title or as against the subheadings that you're mentioning. If you look at the sample table of contents which I have put for your reference, you would see that table of contents will start from abbreviations and end at prayer. Now, abbreviations is also very important and which I will just discuss. You can either write this as abbreviation or list of abbreviations also, then index of authorities, and then if you see, this has corresponding page numbers to it. So this is how a table of contents will look. The next important aspect is list of abbreviations. Now, abbreviations helps in reducing the word count because as you may be aware, most of the moot court competitions have a particular page limit when it comes to preparing your arguments advance or maybe a word limit to your entire memorial. So abbreviations will always help in ease of cross-referencing and they will also help your word count to be reduced. While making the memorial, you may use a couple of abbreviations time and again. And list of abbreviations will contain all these abbreviations which you have used in your memorial. For example, you may be using Supreme Court very often. So you may use that as SC. Similarly, you might be using something like a High Court. You may use that as HC. Then you might be referring to judgments and using AIR. So All India Reporter. So all these are your abbreviations, right? Always remember that when you're using abbreviations, whether it is SC or HC or AIR, do maintain a uniformity in using those abbreviations. The way you write that and the way you use it will ensure that you are using the corresponding abbreviation in the list of abbreviations with the full form. I'll show you how a list of abbreviation looks. This is how it looks. So if you look at it, in this memorial, there were a couple of abbreviations which were used. AIR, All India Reporter. Then let's go and discuss the next component, which is your index of authorities. Now, as the name suggests, authorities includes all your cases which you have relied upon, all the books that you have referred to, all your parliamentary debates or some reports or committee reports, commission reports, journals that you may have come across while drafting your memorial. So your index of authorities will contain all of this. Every information that has been used and that you have cited or that you have quoted needs to be a part of your index of authority. So this is very important for you to have. The second important aspect is that this index of authority acts as a reference. Now, it acts as a reference in the sense that the judges will be able to refer to this index of authorities vis-a-vis the cases that have been cited, vis-a-vis the legislations which have been used. So you can easily navigate the judge to the particular index of authority to say that, Your Lordship, I have mentioned this judgment here and this also forms a part of my index of authorities. You can also refer to the relevant paragraphs of that judgment. So that is why index of authorities is very important. Your index of authorities will look something like this. This is a sample index of authorities. So if you see, it starts from acts and legislations. The names of the acts are mentioned here. The list of cases have been mentioned. Always remember to put your cases with the citation. Follow the proper citation format. If you see, the citations have been mentioned here against the name of the case. After your list of cases will be the books that you have referred. Again, when you quote the books or when you name the books, it is also to be mentioned in a particular format. Do follow this format. So if I'm referring to K.D. Gore, this is a very prominent criminal law book. So I write the name of the author first, then I write the name of the book, then I write the edition, then I write the publication house. So this is how I usually one has to quote or one has to put the name of the book. Okay. And then if you have referred to any law dictionaries or any other relevant relevant material. So law dictionaries, normally we refer to, it depends from mood to mood, but sometimes Black's Law Dictionary is one dictionary which usually people refer to. So Black's Law Dictionary has been mentioned here, and it depends. If you've referred to any other dictionary as well, you can easily quote it here. If suppose you've referred to any committee reports, then make another new subheading and write reports, committee reports, and then just enlist the committee reports or the law commission reports. A lot of people refer to law commission reports also, depending upon the subject matter of the memorial. So mention the law commission report. Next important component of your memorial is the statement of jurisdiction. Now this is where your main body of the memorial starts from. All of the aspects that I discussed till now were the starters to your memorial. This is the main body. So your statement of jurisdiction. Now your statement of jurisdiction, basically what is jurisdiction? Let's understand what is jurisdiction first. Jurisdiction is the authority of a court to hear and determine the cases. It is usually invoked by the party which is filing the case. So suppose if I have a grievance, I am filing the case before a particular forum. So I have invoked the jurisdiction of the Honorable Supreme Court of India under Article 136 of the Constitution. So it is usually invoked by the party who's filing the case. The respondent or the defendant, as the case may be, usually submits to the jurisdiction of the court, or in case has to oppose to the jurisdiction, then in that situation, he will oppose the jurisdiction taken by the appellant and say that the jurisdiction of the court is under XYZ other article. All right. Always remember to mention your jurisdiction very clearly, because this is where most judges will question you on, that under what provision of law have you invoked the court's authority to determine your case. And you have to be very, very thorough with that particular law that you are invoking the authority under. If I am invoking it under, for example, under Article 136 of the Constitution, then I should be well versed with the elements of SLP. In what situation is an SLP specially petition filed? What are the grounds? In what situation can I have filed an SLP in this situation or not? I have to be very, very sure of that. So there shall be no issue while you state the statement of jurisdiction. It should be as clear as possible, and you should be as thorough as you can while mentioning this. So normally how we write statement of jurisdiction is that we normally write it in a form of a paragraph, and we quote the particular relevant clause under which you're invoking the jurisdiction. So suppose if I am talking about Article 136, I will put Article 136 there, and I would say that the Honorable Court has jurisdiction under Article 136 of the Constitution of India. So I'll show you how a statement of jurisdiction looks exactly. So this is for your reference. If you would see, in this we have taken Article 136 of the Constitution of India and we have reproduced that here. This is how you normally do it. This is the manner in which you do it. Now the next important component is the statement of facts. We have already discussed how facts are important and how facts should be prepared. When I discussed in my last video with you that you should always, while researching, prepare a chronology of facts. So now what are statement of facts? Statement of facts in a memorial is basically the summary of your moot proposition. So your moot problem may range from 2 pages to 20 pages. Depends on the moot problem. However, in your memorial, the statement of facts should be able to convey to the judge a brief summary of what the factual scenario is. It should be brief, it should be crisp, it should be articulate. You should be able to communicate exactly what the facts are in a very articulate manner, and ideally should not exceed 2 to 3 pages, subject to the length of the moot court problem. Now, these statement of facts, more often than not, will act as a point of reference for the judges, because in a lot of moot court competitions, the judges only read the memorial at the time of oral arguments. They do not read the moot problems beforehand. That happens in most of the moot court problems because the judges are always busy or occupied with something. Now, your statement of facts will act as a point of reference to the judge. You can always take the judge to your fact sheet, which is the moot problem, and you should always take your judge to the statement of facts, so that the judge is able to give you marks and say that, all right, this moot team has actually worked and prepared the statement of facts. Your statement of facts will not be, and should not ideally be, a copy paste of the moot court problem. Never copy paste your moot court problem in your statement of facts, because if you do that, you will lose out on marks. Okay, so your statement of facts is basically, as I explained, a summary or a synopsis of facts, and ideally it should contain those relevant facts, those facts which are relevant to your side or to the issues which you have taken in your arguments. So prepare the facts accordingly. Now, this is very important. Your statement of facts or your knowledge of the relevant facts should be at the tip of your tongue. You should be aware of all relevant facts in brief, especially both the speakers who are arguing the case before the judges. Because if a judge is asking you something, you should be in a position to navigate him exactly to the moot problem, the para number or the page number of the moot problem, and tell him that this fact finds reference at this para and this page of the moot problem. So the speakers, and I emphasize while I say this, that the speakers have to have a very strong grip on the statement of facts and on the facts in general also. Now, let me share 2 tips with you on statement of facts and how you should actually draft your statement of facts. First is, never assume facts. As I already explained, never assume or add any facts. Facts are never in dispute. Facts are the same. You have to just mold them and use them to your advantage. The second is, follow a chronology of events while you're preparing your statement of facts. Because if you follow the chronology, what happens is that you will be able to tell the judge that this event happened, after this certain event happened, and hence this event happened. So your chronology is such that you are able to structure the events in your mind. So this is my tip to you. And as I already said, do not copy paste from your moot problem, because if you copy paste, then it's a reproduction of your moot problem. In that situation, you will lose out on marks. So always remember these 2 tips. Let me show you a sample statement of facts. This is how it looks like. So normally you should always put your facts in a paragraph form. You can also put it in points, it's not an issue, but always put it in a manner that you're able to communicate it simply to the judge. Don't use very fancy English. Stick to basic use of English and basic use of the facts. This is how your statement of facts will look like. Now let me take you to the next important aspect, which is the statement of issues and why it is important in a moot memorial, what role it plays. Issues, as I have already explained, is your point of clash. Once you have identified your legal issues or the points of law which are involved in the case, you have to prepare a small statement, which is an introductory statement of the issues which you have been able to identify. Normally it starts with whether. So whether A has committed breach of contract or not, something like that. Usually, if you would see in any moot court competition, if the issues are already given, the issues may range from 3 to 4 issues, typically. In some situations, it might be higher. If you have to identify issues and frame it yourself, ideally, you should have 3 to 4 issues to support your case. Now, these are basically simple statements which are stated in a question format. So I will show you how a statement of issue looks like. Simply, it looks like this. So if you see whether the special leave petition is maintainable before the Honorable Supreme Court of India, simple issue, simply put, whether the statement of Balan can be relied upon or not. It's a very simple issue. You have to prove your case basis this issue. You have to advance your arguments basis these 5 issues that have been mentioned. All right. Now let me take you to the next important element, which is the summary of arguments. Now, as the name suggests, summary means a synopsis, right? Why do we have to have a summary of arguments is might be your question in your mind when we talk of a Moot memorial, because of course we will have arguments advanced, which is the next part to this, or your main arguments. So why is the summary important? Now, more often than not, what happens is that summary gives a basic idea about your entire main argument. It gives a synopsis, a brief synopsis of the arguments which you have taken in the arguments advanced section. So this summary is important. So it's this simple. If I write an essay or if I write a research paper, I have to put an abstract to it. That abstract gives a basic introduction or a basic synopsis of what my research paper contains. Similarly, the summary of arguments gives a brief synopsis of what my arguments advanced is all about. So each summary should ideally not exceed 1 paragraph or maybe 2 paragraphs depending upon what your issue is. The summary of argument provides a brief overview of what a party intends to argue in its oral rounds. So this is important. Now let me show you a sample. This is how a summary of argument looks like. You write the name of the issue. You write a brief summary in 1 paragraph of what the argument you are planning to take or what argument you've taken in your main arguments, and you proceed further. So it's a very brief synopsis of ideally, the summary of arguments is always drafted after or always prepared after your main arguments have been prepared, because you take the summary out of the main arguments only. So always prepare your summary towards the end of it. Now, let me take you to the most important aspect or the most important component of a Moot memorial, which is arguments advanced. Now, arguments advanced is the most important aspect of a memorial because it contains, of course, your entire case which has been taken by a party. Now, the issues which you have taken, you have to elaborate on those issues at length. In this, while you elaborate, you have to keep in consideration 2 things. The facts, the law, rather 3 things, and the authorities that you have relied upon. That is what your arguments advance will cater to. So you put your issue, then you put what are the relevant facts here, what is the law, and then you put the relevant authorities. So you have to describe at length your entire case while you refer to all the relevant cases, you refer to all the relevant authorities, and you refer to all the relevant material books that you have perused or you have read while drafting your memorial. Now, arguments which you take and while you draft your memorial, the arguments advanced section has to be very, very clear and very, very unambiguous. It has to have a flow when you are drafting it, because the judge is going to read that and understand your case on the face of it. As much as the judge will also listen to you while you're advancing your oral arguments. However, if you look at it on the face of it, the judge is going to read your memorial first. So it is very important for you to have a clear structure before you start to draft your arguments advanced. Hence, it is very important for you to put that structure on paper. So have that structure in your head. If you have to prove whether A has committed breach of contract or not, you should have a structure in mind as to how you want to prove or disprove this issue. And clearly and unambiguously state that. Now, arguments advanced for the sake of convenience and reference can also have further subheadings to justify the content or the information which one wants to put. Because sometimes what happens is that the issue is very complicated and you may want to have certain small sub-issues in it to prove your main issue. So it is prudent and it is advisable for you to have small subheadings in it. If you have subheadings in it and if you put that subheadings and you put the relevant information under that subheading, it is going to ultimately prove your main issue. So having subheadings is not an issue. Now, in your arguments advance, as I explained, you have to refer to all the relevant legislations that you would have relied upon or referred to, the judgments that you may come across and that you may want to refer to while you're drafting the memorial. Always remember, do not refer to any judgment which you are not aware of completely. Only refer to judgments which you have read and you are aware of what they say and how they're relevant to your case. Because in your oral arguments, more often than not, a judge may question you on a particular judgment or a particular case that you have relied upon or cited. And if at that point of time you are not aware about that judgment, then it reflects bad on your entire team and your performance as a team. So always remember to use or rely upon only those cases which you are thoroughly prepared on. And the cases which you rely upon have to be from the court which is at par or from superior courts. So of course, if the matter is before the Supreme Court of India, you can definitely rely upon high court judgments, but they will have a persuasive value. So it's always prudent to refer to most of the Supreme Court cases because they will have a binding value on the case that is in front of you. You can of course use foreign judgments and foreign case laws also. There is absolutely no issue. However, be very thorough before you use them. So this is on your arguments advance. Now, key tips, as I've already given you tips, but however, there are some more tips. You have to be having a structure. It has to be well organized and it should be such that it convinces the judge. Of course, always focus on writing small sentences. Don't focus on writing a very long sentence because that just breaks the flow of the entire argument. Focus on having subheadings if you feel the need. Do not exceed the page limit if there is one written in the moot court competition rules. Always try and present your argument in a logical manner with appropriate number of authorities. Don't go overboard with the legal authorities, or don't go overboard with citing cases just for the sake of citing, because in that situation you will jeopardize your content which is on paper. So these are some general tips. Now let me show you how it looks like. Your arguments advance looks like something like this. So the argument, the first write the issue, whether the special leave petition is maintainable before the Supreme Court of India or not, and then you put forward your argument. This is how you actually put it. And if you see, you footnote all your relevant authorities, or if you refer to the fact sheet, you footnote that. Now, this is the last component when we talk of moot court competitions or when we talk of memorial, and this is the most important component. Why is it important? Prayer basically is the relief that you want to claim. Your entire argument has been revolving around what you want from the court. What remedy do you want from the court? What relief you want from the court? So prayer is very important. It is the relief which a party is claiming based on the issues that they have taken. And it clearly declares what an individual, whether a petitioner or a respondent, actually wants from the court. So suppose if it is a breach of contract issue, if I'm claiming damages, then I will seek for the amount of damages in my prayer clause. And you can claim as many reliefs as you want. However, it is advisable to stick to 3 to 4 main reliefs that you may want to claim. I'll show you how a sample of the prayer clause looks. This is how a prayer clause looks like. So these are the standard wordings of it, and the 1, 2, 3 points that you see are subject to the case in hand. So suppose if I'm talking of an SLP, then I will, and if I am from the opposite side, then I would say that the SLP ought to be dismissed. And if I am from the side which has filed the SLP, then I will say that the SLP stands maintainable before the Honorable Supreme Court of India. Similarly, if it's a breach of contract, if I am from party A's side, if I'm the counsel on behalf of party A, and if I'm saying that whether A has committed breach or not, I would say A has not committed breach. So I would say that A is not liable for breach of contract, or A is not liable to pay damages to B. So I'll put the prayer accordingly. So this is the most important aspect. So I hope the components of moot court have been clear to you. And I hope you will be able to understand the nuances of drafting and the components of a memorial for that matter in this third video that I have shared with you. And in the next segment, we will discuss on how the oral rounds, or how a team should prepare for oral rounds, and what and why the memorial drafting plays a significant part in your oral rounds as well. Thank you so much. Vishu, I'm done. Vishu, Vishu.